Hello friends, how are you? Today I am going to discuss an important judgment of Honorable Supreme Court concerning Section 7, Section 13(1)(d) of PC Act. As we know that for prosecution of a person under the PC Act, demand is sine qua non. If demand is not proved, in that scenario, it could not be said that a person is guilty under the provisions of PC Act. Friends, concerning same, we are having multiple judgments of Honorable Supreme Court and even Honorable High Courts acting within territory of India. But the key point is that for the first time in the history of India, it has been pronounced by Honorable Supreme Court that if there is mere allegation that the concerned public servant is enriched by misusing the authority entrusted to him by the virtue of law, in that scenario, if the allegations are not supported by any demand, acceptance, recovery of money, in that scenario, mere allegation of demand cannot be a basis for the prosecution of the public servant under Section 7 of the PC Act. Concerning same, please note down the recent judgment, that is Dilip Bhai versus State of Gujarat. Judgment is pronounced by Honorable Supreme Court bearing petition number 2025/25. It is dated 27th of February 2025. In the said judgment, the basic principle emphasized by Honorable Supreme Court is that for the prosecution of a public servant under Section 7, 13(1)(d) of PC Act, demand is sine qua non. If demand is not proved, in that scenario, prosecution would be bad in law. Apart from that, mere allegation of demand cannot be a basis for prosecution. And in addition to this, if there is bald allegation regarding misuse of authority, but said allegations are not supported by demand, by acceptance, by recovery of money, in that scenario, the public servant cannot be prosecuted. Friends, in the case at hand, the concerned accused petitioner was a minister. Inter alia, he allocated fishing contracts without following the tender process, without following the norms of government. And apart from that, grant is inclined from his side. The said process had been challenged by a complainant, and ultimately Honorable High Court is of view that the process of giving grant is upset, it is not transparent, and inter alia it is ordered that the process of giving or allotting the fishing contract must be on tender basis. And apart from that, when the tender process had been commenced, in that scenario, the bid amount was on lower side, and ultimately huge loss had been caused to the concerned exchequer, means the concerned government. Ultimately, the matter had been reported to the concerned authority. In the meanwhile, the concerned petitioner accused had resigned, and inter alia proceeding had been initiated against him under the provisions of PC Act. The basic allegation of the concerned agency is that inter alia he misused the authority, inter alia provided benefit to the concerned persons known to him, and in the whole process, he inter alia enriched himself in unjust manner, and inter alia he obtained undue advantage. But the primary key that was put up by the concerned accused is that for the prosecution of me under the provisions of PC Act, specifically under Section 7, Section 13(1)(d) of PC Act, it is required to be shown that I have demanded acceptance and there is recovery of money, because these are the essential element for the prosecution of an accused under the protocol of PC Act. If these elements are not on record, on basis of mere assumptions, mere presumptions, I cannot be prosecuted. Even the said contentions had been raised by him before the concerned trial court, before the concerned high court, but both the courts had erred while not considering the valuable material legal contention. Apart from that, the key point is that demand is sine qua non. If there is no demand, the prosecution cannot be stand. And inter alia, he sustained the argument based on judgment of Honorable Supreme Court verdict, Neeraj Datta versus State of NCT. Judgment is 15th of December 2022. In the said judgment, it has been differentiated that while having a prosecution of an accused under Section 7 of PC Act, it is required that he voluntarily accepts the offer given by the complainant. And for Section 13(1)(d), it is necessary that inter alia he demanded and accepted. And apart from that, in the subsequent judgment with same title, judgment is pronounced on 17th of March 2023. It has been held that mere demand of money or undue advantage cannot be a ground to prosecute the accused under the protocol of PC Act. In that case, the accused person had been charged, and inter alia they were acquitted from Honorable Supreme Court. The basic concern is that he submitted that if demand is necessary, demand is sine qua non, and demand is absent, in that scenario, prosecution is bad in law. Apart from that, he submitted that mere allegation of demand of bribe is not sufficient and basis for prosecution. In addition to this, he submitted that misuse of authority is a prime concern on the part of agency, but if such allegations are there, they might sustain a different cause of action, but misuse of authority must be supported by the element of demand, acceptance, and recovery of money. If all these elements are absent, in that scenario, the accused could not be prosecuted. The primary concern of the petitioner accused is that inter alia, the allegation of complainant is that he allotted fishing content without following the process of tender, and apart from that, he inter alia inclined the process of grant. But the key point is that the view of High Court that the giving grant is totally absurd, tender process is to be followed, and apart from that, if tender process is followed and inter alia the consent bid is on lower side, it cannot be said that I am having any ill intention to have the undue advantage or to have undue gain. The mere surmises, mere conjecture cannot be a basis for prosecution. If there is an allegation that I had misused the authority as submitted by the concerned petitioner, in that scenario, the said allegations must be supported by some corroborative cogent evidences of demand, acceptance, even direct or even circumstances. If both the limbs are absent, in that scenario, the prosecution would be bad in law. So, the primary contention of the concerned accused is that even though there is a presumption under section 20 of PC Act, but as rightly observed by Honorable Supreme Court in judgment of Neeraj Datta versus State of NCT, judgment date is 15th of December 2022, that for the prosecution of the accused person under the protocol of PC Act, mere presumption cannot be a basis to help the prosecution to be succeeded in a fictitious litigation. Even though there is a presumption, but to draw the presumption at the preliminary level, the elements must be on record with supporting evidences. If the elements are not on record with supporting evidences, in that scenario, the prosecution would be bad in law. So, the prosecution might say that the accused is guilty, he had misused the authority, but mere averment, mere barred allegations cannot be approved. Every allegation is required to be supported by some corroborative, some cogent evidences, which is duly admissible as per the protocol of Indian Evidence Act or Bharatiya Sakshya Adhiniyam. If the consent protocols are not supported, in that scenario, prosecution would be bad in law. So, looking into the entire facts, circumstances, the prosecution had been quashed by Honorable Supreme Court. So, the said judgment is helpful to those public servants who are inter alia charged with the allegation of misuse of authority, but there is no allegation of demand, acceptance, and inter alia. It is said that they indulged in the activity of having undue advantage. But the key point is that if there is an allegation that they are indulged in misusing of process, but the said contention is not supported by demand, acceptance, in that scenario, the prosecution of the public servant under section 7, 13(1)(d) of PC Act on basis of barred allegations would be the abuse of process, and such prosecutions could be challenged with the help of such citation. So, I think that I would be able to convey you the right thing in the right perspective, so that whenever you are having the said trouble, you may easily use the said contentions and could sustain your defense point before the concerned court, so that you could get the appropriate remedy as per law. So, see you in the next video. Till then, Jai Hind, Jai Bharat.